Chapter 9. This voiceover is intended to highlight several things, but it should be some enhancement for the PowerPoint pages that we do have for this particular chapter, and hopefully this will be of some utility to your understanding of the chapter. Although we have talked about witnesses before and the qualities of a witness, there is some little bit of overlap here. But we have sworn witnesses, everyone who takes the stand other than children takes an oath, and the failure to do so may prevent that person from testifying. The person who's a witness at a criminal trial, whether for the prosecution or for the defense, gives oral evidence of what happened, what was observed, what was seen, what was smelled. Not so much interpretation, but just physically who, what, where, and when. These witnesses also, as the case may bring into court physical objects that the prosecutor has used. Sometimes the defense uses physical objects, and the witness has to authenticate, that is, to explain that this is the genuine article. For example, if it's a prosecutor and there's a knife involved in the case, the witness, often a police officer, has to show that this is the exact knife taken from the crime scene and show where it's been every minute between the taking at the crime scene and being introduced in court. So this explains a lot of the physical objects that you may see introduced in a courtroom trial. We have another category of witnesses. These are expert witnesses. These have specialized knowledge, training, and experience, and they give a court some specialized evidence. Many of us could not reconstruct how an accident happened. Most of us could not look at a fingerprint and compare it to another fingerprint. Most of us as a witness could not definitely give the cause of death for a particular person. So very often expert witnesses are required, and we'll take a look a little more deeply at those. So witnesses basically bring evidence to court. It's sometimes physical, it's more often oral evidence that the witness brings to court. Each witness may be subject to a variety of types of examination. This is true whether it's the prosecution bringing the witness to the courtroom or whether it's the defense bringing the witness to the courtroom. So whichever party called the witness does what's called direct examination of witnesses. Ask questions involving who, what, where, when, not much how, and not much why. So these witnesses are simply asked fact questions to which an answer is given. Each witness who testifies on direct examination, especially for the defense perspective, there's a Sixth Amendment right to cross-examine adverse witnesses, and so this is permitted. Leading exam witnesses are allowed to be questioned using questions that suggest the answer. And so you did this then, didn't you? And usually the witness is to adopt that or to reject it. So direct examination, who, what, where, when, not so much why and how. Cross-examination, leading questions that the type of the questions suggests the answer the examiner wishes to have. And these, both direct and cross, are done by prosecution witnesses, and it's subject to defense witnesses as well. Impeachment of witnesses. This is where you try to cast doubt on some of the witnesses' perceptions. Maybe ask the witness, did you wear glasses, or do you wear glasses? Yes, I do. Were you wearing them that night? Well, no, I wasn't, or something like that. Rehabilitation of witnesses. This occurs after a witness's credibility has been cast in doubt, maybe as to perception, or perhaps the witness says, no, I wasn't wearing my glasses that night, but I was so close, I'm actually able to see up quite close, and I got a good look. So that would rehabilitate a witness that might have some questions about lens, glasses, contact, enhancement for the vision. This would show that, well, the person didn't need it on that particular night or day in question. Redirect examination is where the person who called the witness gets to ask that person some other questions, usually to clarify things that have been done on cross. And recross examination allows an examination that follows the redirect examination to test credibility sometimes, or to clarify some things that might exist in such a case. As we noted earlier in the course, the essential qualities for a witness are four: the original perception, oath or affirmation, recollection, and an ability to communicate. Original perception, what the person saw, heard, smelled, tasted. Original perception for an expert witness is something that if the expert witness did a test, the witness has observed the results of that test and can explain it to the judge or jury. So oath or affirmation, the person has to simply swear to tell the truth, or if there's some religious scruple against that, affirm to tell the truth. So help them God, if there's a religion involved. Most states and jurisdictions don't usually say so help me God, but many do. The witness has to be able to recollect what happened, remember it, put it in categories, and be able to explain it. And the final one there, explaining it, they've got to be able to communicate. Persons who are deaf can have sign language. Persons who are also sworn, by the way. And so these are the four elements of Federal Evidence 603 and state equivalents. Basically give the form that a witness must give, oath or affirmation, to testify truthfully. And the idea is to impress upon the witness conscience the idea that you must testify truthfully. And that was the reason that the "so help me God" was often used, because the person who was involved might have to meet his maker having told a lie while on earth and under oath, swearing to tell the truth. So that would impress upon somebody the duty to tell the truth. Go through this slide fairly rapidly. We said already that witnesses have to agree to testify truthfully. There's no religious test via the oath. So if somebody doesn't want to swear to God or doesn't want to take an oath, the person just affirms to tell the truth. However, if a witness just does not make any indication that he or she is going to testify truthfully or to understand the duty to tell the truth, or refuses to take any or make any statement indicating his or her understanding of the duty to tell the truth, that witness can be prevented from testifying. Exception here, of course, young children. We've already talked a little bit about this. We have to examine young children. Ohio has a rule: under 10 may not testify unless they're shown to be competent as a witness, and there are a variety of questions, but basically truth or falsity is important in understanding the duty to tell the truth. So the judge may ask questions of a child. A proponent, that is, if the prosecutor wants to bring a child, the prosecutor may engage the child in some questions, and the defense is allowed to do that as well. But the bottom line is, child must know the difference between truth and falsity and understand the duty to tell the truth. The duty of a judge in control of testimony. This is the Federal Rule 611. There are state equivalents, and every state has something similar to this, even if it has its own rules of evidence. And the court has to maintain some reasonable control. Primarily, the attorneys are responsible for deciding how witnesses are called and what order in which they're called and how that's conducted. But the judge does have some responsibility for controlling the order and the mode of examining witnesses. Prevent the number 3 here, prevent the witnesses from harassment or undue embarrassment. And so cross-examination sometimes can get pretty harsh, and that's usually where this might come. Also, if a person wanted to cross-examine a prosecution witness on and on and on, or if the prosecutor wanted to cross-examine a defense witness on and on and on, and replow turf that's already been plowed, the judge may limit the cross-examination, and that avoids wasting of time. And so those are the things that a judge is given the task to make sure that the order and mode of examining witnesses is at least appropriate. On this slide, there's indication that, as we mentioned the last slide, the judge controls the mode and order, but the judge also has other duties. Upon objections to procedure by the court or objections to what other attorneys have done, the judge has to rule on an objection. So if the prosecutor presents a witness and the witness is asked a question that the defense doesn't think the witness should be allowed to answer, there may be an objection. It may be as to the form of the question. It might be that the witness clearly was never observant of what facts the witness is trying to testify concerning, and so there may be hearsay objections that this witness heard that, Your Honor, but it's not firsthand knowledge. So the judge has the duty to rule on objections, and so the judge will make those rulings, and then they're to be adhered to by the parties involved. General rule here, of course, is that a judge gets to ask questions, and the judge generally only asks questions for clarification purposes. If a judge is confused about some of the testimony, the odds are that a jury might well be confused somewhat, and so a judge may ask some clarifying questions. And the problem here is that sometimes judges are old prosecutors, and there have been several cases reported where the judges in effect took over cross-examination of some defense witness and indicated that the judge was more of a prosecutor than an impartial judge, and those cases often are reversed. This section, separation of witnesses, also called sequestration of witnesses, or sometimes it's referred to as putting the witness, quote, under the rule, unquote. And the federal rules allow the exclusion of witnesses from the courtroom. Now you might think, well, how are you going to get witnesses if they're excluded from the courtroom? This simply means that a witness who's potentially going to testify is prohibited from sitting in the courtroom and listening to other testimony prior to the time that witness gives his or her testimony. And often the parties request, the prosecutor may do so, the defense may do so, ask that witnesses simply be prevented from attending until that witness is finished testifying. And what this does is it allows a witness to give fresh testimony untainted by what he or she has heard in the courtroom, and an adjustable witness might be able to tailor his or her testimony based on what he or she's heard in the courtroom to make it more cohesive. And so that's not something we like to see done. Some party witnesses are not covered by any sequestration order, so a real party in the case cannot be sequestered even if he or she is to testify later. The defendant cannot be sequestered and removed from the courtroom, obviously. Generally, a person called the case officer, who's not necessarily an attorney, but maybe a primary police investigator, may sit with the prosecutor, and even if he or she is going to testify later in the court, if the prosecution makes the case that this individual is important to advise me and sit by me and for me to ask questions during the course of this trial, the case officer would be allowed to sit in during the whole trial, even if he or she is to testify at some point later in the trial. So the concept is sequestration of witnesses is allowed and is often done. And what it does is it prevents witnesses from getting their story straight. Each witness who comes to the courtroom is more likely to tell the truth if he or she does not know what a prior witness has stated. Under this sequestration, we noted that natural persons who are parties may not be excluded. That means the defendant cannot be excluded. And government agents may be designated, as we noted, as the case agent, and that person may not be subject to sequestration. We have a remedy if somebody violates the sequestration order, and that may involve the exclusion of that witness's testimony. This is rarely enforced to this level. However, it is quite possible that a witness who violates the order sits in the courtroom, listens to the other witnesses, and then is prepared to take the witness stand may be excluded from offering any testimony. We have two cases in part 2 of the book that we hope you've read, and they deal with sequestration and violation of those orders. And as noted in the cases, there are a variety of remedies for this. One is to let the jury know the person has violated the order. The most exclusive remedy is to say you can't testify, and all kinds of things in between. Also, if it's a negligent violation of the order or somebody hadn't heard of the order, that might be a reason to allow the witness to still testify. And if it would prevent the defendant from putting on any defense, if that was the defendant's sole witness who's violated the order, that person will probably be allowed to testify. As we discussed earlier, each party who calls a witness conducts direct examination of that witness, and the questions that have to be answered generally are asked: who, what, where, and when type of questions. Who was present with you in this bar when the fight broke out? What happened when the husband hit the wife? When did this occur? Was this last year? Was it August? When was it? And questions of where things happened might be in order. So who, what, when, and where questions are not necessarily leading. They are asking for actual facts. So generally leading questions aren't allowed during direct examination. There are a couple exceptions. Young children can be used and ask leading questions because they often answer sort of cryptically yes, no, and so leading questions can be allowed. Also, the beginning of any normal witness who is not a child, leading questions being asked: would you state your name for the record? Yes, it's Ms. So-and-so. And you live in the city of Dayton? Yes, I do. And where would that be? Is that on Stewart Street? Yes, it is. So those are leading questions. They just expedite the beginning part of testimony. and those are generally allowed by a person who would otherwise be required to use direct examination questions. As we noted in the last slide, introductory testimony: who are you, where do you live, things of that nature, what's your name, have you been to college, or some background information can be used. Also, some witnesses are hostile. So let's say that prosecution involving a fight with a male, the male's brother was present at the crime scene, and the prosecution calls that person as a witness. The brother of the defendant probably does not want to gore the ox of the defendant, and is likely to be hostile to the prosecutor's questions. And in such a case like that, the prosecution may have the judge declare the witness a hostile witness, or it may be obvious to everyone in the courtroom this is a hostile witness and is really allied with the other side. So in that context, we can ask leading questions occasionally. A police officer may be called by the defense, who's kind of the officers are reluctant to really help out the defense, but has some knowledge the defendant wants to put on, and that police officer may be somewhat of a hostile witness and not very cooperative, and leading questions can be asked of such a person like that. Also, leading questions can be used to correct errors. So someone states, and where were you on the night in question? Well, I was such and such a place. And when was that? And somebody says, well, that was in 2018, and the prosecutor knows it was really 2019, and the prosecutor might say, did you really mean 2019? Clearly a leading question, but that corrects errors, and that would be allowed. Young children, we mentioned earlier, may be examined using leading questions, and some people with communication problems who either don't understand things normally as another individual might, and so the question can be used a little bit leading to get that person to fully develop his or her testimony. You might ask, what is a leading question? It is a question that by its content or by the way it's asked suggests the answer that the questioner would like to hear. So the questioner might ask something like, you arrived on the scene at what, 10:22 p.m.? Well, obviously the questioner wants the answer from a police officer. Well, yes, I did. But that's a very leading question, and so it suggests the answer by its contents. And then the questioner might ask something, and after you got there, did you encounter the defendant? Is that correct? That's a leading question. Okay, so generally leading questions not proper on direct exam. Small children, people with communication problems are an exception, or introductory material. And leading questions, however, are perfectly permissible on cross-examination and are typically done at that point. This particular slide we pretty much covered in an earlier slide in the suggestion that if there's somebody that might be a hostile witness and the other side doesn't think it's a hostile witness, that's a question that the judge would have to resolve. And if the judge rules it's a hostile witness, leading questions can be used. If the judge says, no, I don't think that's a hostile witness, then leading questions cannot be used. And we mentioned a little bit earlier, a slide or two, that the prosecutor or the defense may use a leading question even where the person is otherwise required to use a direct question under direct examination. Questions that have elicited an answer that the questioner knows is not accurate, and the witness has simply made a mistake. And so if the witness was asked, in what year were you married to the defendant or something like that, or if the witness is asked about that and somebody says, well, 1918, and don't you mean 2018? And somehow if there's a question like that, that's an obvious mistake, leading questions can be used. And so we've also covered the situation of child witnesses and people with some English language complications or don't understand it well. Leading questions can be used there, or other communication problem. We've touched on this slide earlier, but the content of it anyway. When the witness first takes the witness stand, we need to have the person state a name and address and where that person lives. That is very crucial because it may help the cross-examiner be able to give a better cross-examination. And we don't have secret witnesses who testify in American criminal law and evidence. The person has to give his name and connection and other general personal things, but not really deep personal things. But asking a few leading questions here speeds up the introductory material and gets on to the real nuts and bolts of the case. And the questioner, of course, can use leading questions at the very beginning, but then must cease using those and use direct questions if that examiner has the one who's called that witness to the witness stand. We have touched on this before, the hostile witness. This is the case where the witness is really allied with the opposing party. So if it's the prosecutor, as we mentioned, had to call the defendant's brother, that would be a person who's probably allied with the other party. If the prosecutor had to call the defendant's boss, and the boss would like to have the defendant keep working, and if he goes to prison, that won't happen. That might be a person who has sympathy with the defendant, and they can be hostile witnesses for the prosecution or for the defense, either way. And this is generally, you can generally see the answers in the beginning, body language, that the person's not cooperative, changes testimony sometimes, gives an answer that totally surprises the person who's questioning the person, gives an answer that was not known to be true before, and so leading questions may be asked there. The judge may declare the witness a hostile witness, and in some cases, as we had mentioned earlier, the person is known to be a hostile witness simply by his or her demeanor in the courtroom and the way the person's answered a few questions. And neither the prosecution nor the defense would argue that it was not a hostile witness if it's clearly so. We had noted earlier that obviously erroneous statements may be corrected by the use of a leading question, even by somebody who's required to use direct examination. So the leading question is simply used to clarify or correct the witness's testimony. Children pose a special problem when they're required to testify in court, especially young children, even pubescent children and teenage children, young teenage children, and late single-digit children. Sometimes are reluctant to testify. It's a foreign place to them. Sometimes the attorney will bring a child into the courtroom a day or so beforehand to let them sit in the courtroom, sit in the witness chair to try to get somebody comfortable, but often that doesn't work, and children tend to, in circumstances where they're not really happy or uncomfortable, answer cryptically yes, no to questions, and some explanation is sometimes required that the questioner may use leading questions on the child itself. And so sometimes people with some limited English may be embarrassed by their language skills or lack thereof, and so in those people often tend to answer in yes or no rather than expand on what's known, and so leading questions are often permissible in such circumstances. We'll conclude this part of the material because this pretty much covers the material that was given in the first part of this particular assignment in this chapter, chapter 9, going up to the first part that was required. And hopefully this has been of some help or assistance, and very hopefully it has been.